Hello, in this last video on Jurisdiction Online, we'll shortly get introduced to choice of law concept. After court have determined that they have a jurisdiction of a particular case, the next question that has to be answered is the law of which country will have to apply in a particular dispute. It is important to highlight that this is a different question from jurisdiction. Now, it is very often that the court would apply its own forum law as a substantive applicable law. However, in some cases, the court may need to apply foreign law because the dispute is more closely connected with the other jurisdiction. Different choice of law rules apply to different areas of law, such as contract, tort, breach of statutes, and so on. Let's take a look at several examples. In case of contracts, similar to jurisdiction, parties have a right to choose which law applies or governs their contract. If parties have not chosen the applicable law, the courts will first look whether parties have chosen a jurisdiction of a particular court. If such jurisdiction clause exists, it would be normally presumed that parties chose the law of the same jurisdiction where the dispute will have to be solved. If there is no jurisdiction clause in the contract, the law which has the closest connection to the contract will apply to determine the dispute related to the contract. Here one would have to look at the form and legal language of the contract, place of contract, place where the contract is to be performed, as well as place of residence of the parties. This choice of law becomes especially important in online contracts, which often involve international element. Therefore, it is very advisable to indicate choice of law in e-commerce contracts. If it's not indicated, the contract the law applicable to the contract will have to be determined by court, taking into account the mentioned factors. With regard to torts, previously the so-called double actionability rule applied. It allowed for a tort to be actionable. It required for a tort to be actionable both under the law of the forum, let's say Australia, as well as under the law of the place where events took place. This rule you can still find in previous case law, however it has been recently abandoned, and the current applicable rule of law is so-called lex loci delicti rule. It suggests that tort is subject to the law of the place where the wrong took place. In online cases, the same difficulty arises as discussed in jurisdiction scenarios, where the place of wrong takes place in the online environment. In Dow Jones versus Goodnick, it was decided that the place of wrong or the place of harm to the reputation was the place where the content was accessible or downloaded. While in other intellectual property case, Word Group versus Broadstone, that concerned trademark infringement, the court established that it is not sufficient for trademark be accessible in Australia. However, the certain targeting towards Australia needs to be established. Therefore, up to now, there is no clearly established interpretation as how lex loci delicti rule would apply in online environment. On the other hand, it is important to highlight that generally Australian courts are very reluctant in applying foreign law. When a jurisdiction of Australian court is established, Australian courts would normally apply Australian law, and if it is found that foreign law would apply is a substantive applicable on the case, the courts have a possibility under forum non-convenience doctrine decline jurisdiction of a case, in which scenario plaintiff would have to approach a court in a jurisdiction which law will apply to the case. Here we finish our series of video on jurisdiction online. Thank you for your attention, and let me wish you enjoyable classes.